So one step is that most clients who come to you and they report that this is an offense, if they go directly to the police station, the police is going to take a complaint in their general diary. Yep. And they are not going to lodge the FIR because the client will directly write what happened, and you as a lawyer will have that ability that you can actually reduce it into a complaint, and then you can meet the police officer and discuss with them, and they might they will record an FIR right then and there, right? So that is one aspect where you can assist a client in ensuring that the criminal machinery starts. And so here your assistance will be twofold. One is in actually writing the FIR, and what clients make a mistake with is that they identify the facts, but they put in the whole unfiltered version where they are unable to highlight how every element of the offense is connected to the facts. So if you just identify that A, B, C, D happened and this, and you don't have to, if you as a lawyer write it, then you don't have to write the sections, because then the police starts to feel that this is a fabricated FIR and it has been manufactured, it has been written by a lawyer. Right? So you want to write such that all the ingredients are matched to the facts and the story. You can even use some of the wordings in the section. Okay, that he wanted to deprive me of my property. Okay, or somebody who, so these kind of words you can pick up from the section, keep it simple enough so that the police, when they register a FIR, they have to write in the FIR format, which is that different, sometimes it's different for every state. In the format of the FIR, they will write which are the sections we are registering this FIR under. Okay, this is not the official charge, but this is the sections that they will be putting. So the police gets a very clear clue which sections to add there. They will on their own also add additional sections, or they may not put in some sections which you wanted. Right? And if you are acting for a client who's come in and he wants to get a criminal case registered, he will also want कि दूसरे side का arrest हो जाए. Right? So you will have to look at कि what will be the cognizable and non-bailable offense. So you will have to go through that in the CRPC and see कि अच्छा, I can frame the FIR with this because this is the story that the client gave me. But is there some element that I'm missing out on? You may need to ask your client additional questions and frame it such that it is within the framework of a cognizable and non-bailable offense, because that's when it is likely that you can get a outcome of the case, because a criminal trial in its fullest form will go on for years. 5, 6 years, 7 years, anything it can take. And if you want a criminal, so a lot of criminal trials are resolved before. Unless it's a very serious case, many criminal complaints, like you'll have criminal complaints in matrimonial cases also. Right? So yeah, they could be compoundable offenses, but even if they are not compoundable offenses, they are settled before. So what happens is that before the police frames a charge sheet, so after the police completes the investigation, they will frame a charge sheet, or they will close the case by sending a final report. So that instrument goes to the magistrate. If I send a final report, magistrate may take cognizance still. But if I close it, and if I send a charge sheet, then it is highly likely that the police will, that the magistrate will proceed with the trial, unless I get it quashed by the High Court by filing a Section 482 petition. Right? So what is going to happen here is that if before the police completed investigation, parties settle, usually the police is involved in that. Okay? Then this will not go to trial, because the police will issue a final report and parties will settle on their own terms. Police may be involved in getting the parties together informally. That's not put on record. But then the police will say that there were no charges made out. So when you're registering the FIR in the cognizable non-bailable part, just remember that what is cognizable and non-bailable? The offense under IPC or under any other law. So in every state, IPC has state amendments. You will be surprised to find out that something that is cognizable and bailable, you might think ये तो IPC में है, and किसी दूसरे स्टेट में ऑफेंस हुआ है, वहाँ पर वो नॉन कॉग्निजेबल और बेलेबल बना दिया है. तो आपको लग रहा है अरेस्ट होगा इसमें, but actually arrest doesn't happen because in that state the section is different. And iska ulta bhi hota hai. In your state, in the regular IPC section, it says non-cognizable and bailable. You're very happy. Arey client dusra bach jayega. You know, if you're acting for the defendant, bail mil jayega janab. You can say that. But what happens in reality is there's a state amendment which is telling you that this is non-bailable and this is cognizable. So then you're stuck. So you will need to always check